Welcome back to the D&O Diary podcast, and thank you for joining us for episode 5. Today, Kevin and I are excited to welcome our first guest and our colleague, Marissa Streckfus, Vice President and Claims Manager at RT ProExec.
Today, we'll be discussing some of the significant claims trends that Marissa is seeing in the private company space, how policy structure impacts those claims, and recurring claims handling scenarios that can create challenges for policyholders. Welcome to the podcast, Marissa.
Thanks, Kevin, and thanks, Sarah. I'm so happy to be here with you.
Marissa, private company claims against directors, officers, and companies often look different and have different coverage triggers than public company D&O claims. And one common claim that we see made time and time again against individuals and companies involve business disputes. Is that still the case? And can you explain a little bit about what those claims might entail?
Yes, Sarah. So absolutely. We see lots of different types of claims coming in regarding business disputes. So what these can look like or what can be expected from our policyholders are claims that come in from competing businesses that are in the same space as our policyholder. Sometimes they might look like antitrust claims. And we see often claims involving bankruptcy or insolvency of the corporation.
One point you made there, Marissa, that I think is important to emphasize is that those kind of business dispute claims involve not just ownership or shareholder type claims, which I think a lot of people think of as the prototypical private company D&O claim, but also claims from competitors, vendors, customers, suppliers, and those can be very serious private company D&O claims as well. I think that's frequently overlooked. But one question I have for you, Marissa, is are these kind of claims likely to occur in certain industries?
Yeah, that's a very good point, Kevin, because in my experience, that is the case. So I see a lot of litigation of this type among service-oriented businesses. This can include technology companies, professional service organizations, and companies that have a heavy reliance on contractual relationships. So, for example, this might include something like a real estate agency that have individual agents working and may move between competing real estate firms. And also, by way of example, I had a claim of this nature on competition involving an engineering company that was providing critical infrastructure solutions. So, a lot of those types of businesses are the ones that might be ones most likely to see these types of claims.
And one thing I've noticed in many of those cases is that you end up with a complaint filed that might contain both potentially covered and uncovered allegations. And that seems to naturally lead into allocation issues.
Yeah, Sarah, that's absolutely right. So a lot of the complaints you'll see in this space regarding competition and the like are drafted kitchen sink style. So numerous types of allegations that often overlap that can sometimes be confusing to our policyholders who haven't seen that kind of litigation before. But you would see something like wrongful management conduct alongside those sort of pure breach of contract allegations or other claims that arise that can precipitate coverage questions. So, on the one hand, you might have plaintiffs alleging management made wrongful decisions or misrepresentations, but on the other hand, they may be simply complaining about the quality of services that our insured might be providing under a contract. So the different types of allegations that can come through can create fairly complicated questions about whether or not there's a defense cost allocation under the D&O policy, and ultimately if there's an allocation with respect to the settlement or judgment in the case that we're dealing with.
Well, those kinds of conversations about how you're going to deal with the covered and uncovered claims, those can and probably should be dealt with right at the outset, right when the claim comes in. Isn't that right, Marissa?
Yeah, absolutely. So sometimes we like even before substantive litigation activity has even occurred. So like that's why policyholders will benefit from understanding their D&O policy structure well before a claim comes in, rather than trying to pick up on what those issues are during the course of the claim. And so depending on how a claim is pleaded or what allegations arise in the claim itself, coverage can be implicated whole or in part. So coverage may be partially applicable on a defense, and the carrier may pick up on those for an insured and tell them about the allocation issues with respect to settlement or judgment as that comes along. But as you pointed out, Kevin, it's extremely important for that type of litigation, again, with the kitchen sink approach, that the relevant stakeholders take a look at that claim and have an active discussion about the implication of allocation on that matter as soon as possible, and especially with the carrier who's ultimately going to be making that coverage decision.
And Marissa, you mentioned this earlier, but another trend that's attracting significant attention is antitrust exposure. So we've been seeing the DOJ as well as state attorney generals continue to aggressively pursue antitrust litigation. However, that risk, which you again mentioned earlier, is part of, the litany of business disputes that might be filed against a private company, can come from other places than just government enforcement actions. You can also see these lawsuits filed by competitors, customers, suppliers, and even shareholders. So tell us a little bit about what you're currently seeing with respect to antitrust.
Sure, Sarah. So we're seeing an increasing number of allegations with respect to competitive practices, distribution arrangements, pricing disputes, market conduct, and this speaks back to our discussion about the service-oriented businesses that may be subject to this type of litigation. So those businesses or those policyholders with private D&O in expectation of these kinds of claims might not have historically viewed themselves as targets of antitrust disputes, but that's obviously changing, and we want to make sure those companies are aware that that might be something that they could have exposure for. So companies of all different sizes are facing scrutiny on how they compete and interact in their markets. And, just by way of example, the Columbia Law Review published a study this year finding over 2,000 instances of individuals sitting on boards of companies that were in direct competition from each other, which, as you guys know, is prohibited conduct under Section 8 of the Clayton Act. And sort of a point further on that is, as we know, a lot of private companies may be subject to private equity ownership, which sometimes will place those private equity partners on various different boards, and again, who might be in direct competition with each other.
We refer to these kinds of claims as antitrust claims by way of shorthand, but I think we all know that the claims might not necessarily be restricted just to allegations of the federal antitrust statutes, that often they can include state statutory or common law allegations such as deceptive trade practices, unfair trade practices. And so it encompasses a broader array of legal allegations and often factual allegations. And it has significant implications because of the wording of the antitrust exclusion that is found in some private company D&O insurance policies. But the one thing I know for sure from having seen a lot of these over the years is they can be very expensive to defend.
Yes. Yeah, Kevin, that's exactly right. So if it wasn't apparent already by the kinds of things we were talking about, dollar signs are associated with all these kinds of claims too. So even when liability hasn't been established on a claim of this nature, the cost of responding to an antitrust lawsuit, to an unfair trade practice lawsuit, to a price fixing lawsuit can be substantial because these cases often involve extensive discovery, large document production. Oftentimes we need economic experts involved in the litigation and very long litigation timelines when those cases are in court.
Yeah, and I know that oftentimes there are lawyers that specialize in antitrust that certainly can charge for the defense of this type of litigation.
Yes, absolutely. And I think that's a good point, Sarah, because when we're talking about triggering on the directors and officers coverage, that is an important piece to have a discussion with the carrier about who the appropriate attorneys will be on the claim, because that is of utmost importance, is that the procedure of the litigation be done by competent counsel.
Marissa, let's talk about another scenario that I think we all recognize often leads to D&O claims, particularly private company D&O claims, and that's circumstances involving financial distress at the insurance company. I think we all know that one of the most important things a private company policy can do is to be available to respond in the event of insolvency or bankruptcy. And it has a lot of important implications from a claims management, claims handling, and policy structure standpoint.
Yes, absolutely, Kevin. So to that point, the important part of a D&O policy is oftentimes to not only protect the business itself, but individuals on a corporate basis from their own personal assets being targets of litigation like this. So again, in the bankruptcy context, that's why having appropriate directors and officers coverage in place from the outset is extremely important. And so in this day and age, with a lot of economic uncertainty, we have continued pressure on private companies, and which ultimately will inevitably lead to bankruptcy or financial distress. And so oftentimes with the initiation of a bankruptcy, the scrutiny of management decisions often follows, and our insureds could be subject to various types of bankruptcy style litigation. So, and again, by way of example, Chapter 11 bankruptcies were up over 50% in the first 6 months of 2026 from this time last year. So this is absolutely sort of a point that private company D&O purchasers need to be aware of. So what kind of claims come out of this scenario? Claims from bankruptcy trustees, claims from receivers, creditor committees, liquidating trusts, and individual creditors. So anybody who might have a stake in that organization, and what occurs in the course of the dealing with the bankruptcy or financial distress is really important.
And the allegations that we may see in those claims, right, during the bankruptcy proceeding, or if
Yes.
there's a complaint that's filed within that kind of proceeding, are
Yeah.
those allegations surrounding the breach of fiduciary conduct by the
Mhm.
individuals that you mentioned previously.
Yeah. So like we said, a financial distress situation will often put a microscope on the conduct of managers with respect to the organization. So you'll see allegations involving breach of fiduciary duty, if there's any favoritism that the company might be having to certain stakeholders of the organization over others, if there's inadequate oversight, lots of issues involving transfer of assets. Again, we're talking about, a unfortunate financial situation. So those transactions are going to be, on close review, or other decisions that were made during the periods of financial stress or anything leading up to that bankruptcy or during its procedure.
One of the things about the D&O policy and responding to bankruptcy related claims is the importance of the policy structure. And in some ways, the way the entire policy is structured is built around trying to maximize the response of the policy in the event of bankruptcy. So I think structure is one of those things that to non-professionals may not seem as important, but it is particularly important in this context.
Yeah, you're totally right, Kevin. So when a corporation may have bankruptcy befall it or become financially distressed, it's really important for them to understand a whole slew of the structures that you're talking about. What limits are available under the policy, what retentions are applicable, to the organization or insured persons, and at what point those might be applicable, priority of payments that are required under the policy. A lot of times in bankruptcy, you might have insureds suing other insureds, which may implicate our insured versus insured exclusion in a private company D&O policy. And then the overall design of the program really has a spotlight under it during financial distress, as that may respond to our policyholders during that time.
Thank you, Marissa, for that overview of the current private company claims trends we're seeing, as well as I think especially kind of how coverage can interplay when those claims are filed against a policyholder. So now that we've covered the emerging risks, let's turn to claims handling, the nitty-gritty, and discuss some of the common pitfalls and challenges that organizations face after a matter arises.
Marissa, in my experience, the most often occurring claims problem are notice issues. They come up for a lot of reasons, often because the policyholder doesn't recognize an event as representing a claim under the policy, or they don't recognize that what happens triggers on their part an obligation to report to the insurer. But the one thing I know for sure is that notice issues come up over and over again.
Absolutely, Kevin. Something I see on a day-to-day basis at my desk. And I think the issue can, in a certain way, be boiled down to that many of our policyholders still look at merely litigation as the triggering event for coverage under the policy. But as we know, prior to a litigation being initiated, there's oftentimes lots of written discussion going on, all of which may point to a claim arising. So I have situations where insureds think that they're merely having a discussion with a party and trying to work it out. figuring out like what that business dispute might be or what kind of competitor issue might come up, not realizing that some of the things said in those correspondences actually might trigger coverage under the policy. So when you have that disconnect between is this conversation that we're having or this correspondence that we're having a claim or not, we oftentimes will miss reporting obligations under the policy and on account of our insureds weren't aware that that communication may have triggered coverage.
I think one of the problems is that the broad definition of claim in the policy, that although it's generally thought of as a very positive thing for the policyholder, that there's a broad range of kinds of things that could potentially trigger a claims made coverage. The reality is the broad definition of claim can create pitfalls for policyholders that may not recognize a certain circumstance that falls within the definition of claim also triggers a notice reporting obligation.
Yeah, Kevin, exactly. So in my experience, most of your private company D&O policies and many other policies that we deal with, the definition of claim includes a written demand for monetary relief or non-monetary relief. It's usually easy for us to figure out what monetary relief is because that's a demand for a certain amount of money. But what constitutes non-monetary relief is fairly amorphous. It can be many, many different things. And that's really what it seems to trip a lot of people up is sort of just like, is this communication really demanding something in the form of relief that may not be money?
Thank you so much, Marissa, for kind of going through those initial considerations that both underwriters and certainly brokers need to have at top of mind. So let's talk a little bit then about claim interrelatedness. Why does that issue come up so often?
It's a really good question, Sarah, because as we know, with talking about notice, like these disputes really don't always arise from a single event or issue. So you might have, a pre-litigation demand letter followed by a books and records request made upon a board, followed by litigation, and then followed by, shareholder derivative action. So we got lots of different things going on. And so we have questions come up for coverage as to whether or not those matters are separate claims. Again, the important part there, are they subject to different retentions or deductibles, or are they going to be deemed as one claim interrelated under the policy? This can affect, as we said, what retentions are applicable, which particular policy the insured holds might be responding, what limits are applicable in that regard. Again, going back with whether notice was timely, and in certain part, whether there are prior acts or retroactive date issues that might come up with that. So this is why interrelatedness frequently becomes one of those like very acute analytical points in the claim, and important for our insureds to get really good support about on those issues too.
Well, Marissa, I know this was a pretty high-level overview, but I want to thank you so much for sharing your insights today.
Thanks, Kevin. I appreciate being here with you.
Thank you all.